Technology has revolutionized access to information, and this is especially true for people with disabilities. Growing up, there were hundreds of books around my school, but I couldn't read most of them. As a blind student, I needed books in Braille. The school had only a few dozen books in Braille, which limited what I could read and limited what I could learn. Technology has the potential to end old barriers, and lawyers are key to helping make that social change. For example, back in 2008, Amazon released Kindle e-readers. Kindle e-readers had the potential to have access features like text-to-speech or support for digital Braille. When a book is in a digital format, it's really easy to convert that book into an accessible format, like large print, audio, or digital Braille. Amazon turned off the text-to-speech feature in many of their books and showed no interest in supporting digital Braille. The National Federation of the Blind is the largest organization for blind individuals in the United States, working to promote civil rights for blind individuals. Lawyers in the NFB use community education, legislation, and litigation to push Amazon to prioritize accessibility. Lawyers in the NFB inspired me. I want to be one of those lawyers. I want to help create a world where all students can access books at the same time, on the same device, and for the same price. There are over 2.1 million students with disabilities enrolled in higher education. Historically, colleges and universities have struggled to provide accessible instructional material to those students. Accessible instructional material includes books on tape, books in large print, books in Braille. There are a couple organizations around the country that provide books in these alternative formats. Professors will sometimes assign books that are not available through one of these organizations. That means the school has to manually scan each book, proofread it, and convert it to an accessible format. That takes time and money. Students with disabilities end up waiting weeks or months to get their accessible copy of the book, which causes them to lag behind in their courses. The Higher Education Opportunity Act of 2008 created a commission on accessible instructional material. That commission found that access issues are a major barrier to the success of students with disabilities. The U.S. Supreme Court said in Brown versus Board of Education that separate is inherently unequal. Like racial segregation, giving students with disabilities different material, separate material, has resulted in inferior educational opportunities. Now, for the first time in history, schools have the opportunity to provide accessible materials on the same device, at the same time, and for the same price to all their students. Exciting new developments in technology have made it possible for mainstream devices to have accessibility features. For example, Apple's iPad has captioning for individuals who are deaf or hard of hearing. For individuals who are blind, it has magnification capabilities, text-to-speech functionality, and supports wireless Braille displays. It also has assistive touch for individuals with mobility impairments. Apple has a wealth of accessibility features on their devices, from iPhones and Macs to iPads. But this wasn't always the case. The NFB, the National Federation of the Blind, and the Massachusetts Attorney General's office approached Apple about the inaccessibility of iTunes U in 2008. Separately, but at the same time, Cal State approached Apple and told them they would not use iTunes U so long as it was inaccessible. iTunes U is a web service that allows educational institutions to share educational content, videos, books, lectures. Apple learned through negotiations with the NFB and with the Massachusetts Attorney General's office what they can do to make iTunes U more accessible. NFB held workshops, held training, gave them ideas of what they can do. And Apple's said, okay. They did it. They made iTunes U accessible. And from what they learned from the NFB, they completely changed their attitude to accessibility. So after that agreement in early 2009, Apple came out with the first iPhone that had accessibility features built in, the iPhone 3GS. And all their products after that have had accessibility features. And that occurred through education, through training, through friendly negotiations. The first role of disability rights lawyers is to be educators, to educate the community. And that's the lesson that we can get from that story with the interaction of Apple, how Apple came from the dark side and became a friend. Community education comes in many different forms, from friendly roundtables to peaceful protests. So Apple has agreed to make their products accessible, but unlike Apple, Amazon's Kindle and Barnes & Noble's Nook have little to no accessibility features. The NFB and other organizations have pushed to get these organizations, have pushed to get manufacturers to make their products accessible. They started with friendly emails and friendly phone calls. Back in December, the NFB held a peaceful informational protest outside of Amazon's headquarters. People held signs saying, "Fix Kindle books," "Equal access in the classroom." They sang Christmas songs with a twist about accessibility and how all I want for Christmas is a Kindle. And that was their way of getting the message out to the community, to the people of Seattle and Washington, to the greater United States, to the president of Amazon who was sitting in his office. And when you educate the community about what can be done to make products accessible, sometimes they'll do it, as we saw with Apple. But sometimes friendly negotiations doesn't work. And the specialty of lawyers is they know how to use the legal system. If friendly negotiations don't work, litigation is a last resort. The NFB has moved to use litigation to push Amazon to prioritize accessibility. The Americans with Disabilities Act and the Americans with Disabilities Act, known as the ADA, actually doesn't require manufacturers to make their products accessible. Directly, it doesn't, but indirectly, it does. What it does directly is it directly tells schools that they are prohibited from discriminating against students with disabilities. When schools require the use of technologies that are not accessible, they are violating the ADA, and they are violating another law called Section 504 of the Vocational Rehabilitation Act. So when schools construct new buildings, they have to plan for ramps and elevators. When schools create new programs that use technologies like Sony readers or Kindles, they have to think of the electronic equivalent of ramps and elevators. The NFB has filed complaints against several schools. The U.S. Department of Education and the U.S. Department of Justice have both issued statements saying the use of inaccessible technologies violates the ADA and Section 504. The first role of lawyers, disability rights lawyers in particular, is that of educators, community educators. The legal system's promise of equality heavily depends on lawyers, and disability rights lawyers heavily depend on community education. On the slides here, we have the Harvard Law Project on Disability holding disability rights workshops and trainings in Korea and China. And then we have the president of the NFB at a podium promoting civil rights for Americans with disabilities. Without lawyers, many discrimination issues would remain unresolved because victims of discrimination may lack the money, skills, or perseverance to sway inflexible institutions. As more and more schools transition from printed text to electronic instructional materials, lawyers are needed to remind them of their legal obligation to make sure their materials are accessible to all their students. Lawyers, especially lawyers with disabilities, are important in helping make that change in education. I'm currently a third-year student, and I'll be graduating in May. I will have a Skadden Fellowship to work on, and my role, inspired by the NFB, will be to educate educators in California about what they need to do to make their products accessible, their legal obligation to use accessible instructional materials. If friendly negotiations don't work out, litigation is a last resort. Lawyers are community educators first and foremost, and they have the special skill to rely on litigation if friendly negotiations don't work out. Through the work of lawyers in the NFB and other disability rights organizations, we're moving towards a future where all students can access their books at the same time, on the same device, and for the same price. Thank you.